Welcome back to Uprising. I'm Sonali Kohatkar. Jury selection has begun in the case of the Boston Marathon bombing, called simply the United States versus Zhokar Tsarnaev. The main requirement for those serving on the jury is that they be willing to impose the death penalty. The federal trial will take place in Massachusetts, a state that has abolished the death penalty. It could last as long as 4 months. Now, despite his opposition to the death penalty, Attorney General Eric Holder has announced an exception in this case, citing Tsarnaev's, quote, especially heinous, cruel, and depraved manner. Mr. Tsarnaev faces 30 counts, including conspiracy to use a weapon of mass destruction. He has pleaded not guilty to the indictment. At stake is a series of twin bombings of the Boston Marathon on April 15, 2013, which killed 3 people and injured hundreds. Tsarnaev and his older brother Tamerlan were chased by police, during which the brother was killed. Apparently, among the pieces of evidence that prosecutors in the case will use against him is his opposition to the U.S. wars in Iraq and Afghanistan. My guest is Marjorie Cohn. She's a professor of human rights at Thomas Jefferson School of Law, also the past president of the National Lawyers Guild. She was also the editor of the United States on Torture, Interrogation, Incarceration, and Abuse. Welcome, Marjorie.
Thank you, Sonali.
Now, Tsarnaev's attorneys had petitioned for this trial to be moved outside of Massachusetts, where the atmosphere is likely not in favor of the defendant, given that the attacks, of course, happened in Boston. But a federal appeals court denied that request. Is that a problem, do you think? Where this trial is taking place, does that already sort of set it up for a problem with respect to due process?
Absolutely, Sonali. In the Oklahoma City bombing case, Judge Mach ruled that nowhere in Colorado could Timothy McVeigh and Terry Nichols get a fair trial, and moved it to Denver. And the case in this particular case, the Tsarnaev case, there's even a stronger case for a change of venue motion, because the government in their aggravation papers said that everyone in Boston is a victim. So what we're talking about is it would be impossible to get a fair trial because every prospective juror would be a victim in the case. And in fact, the Court of Appeals ruling that you just referred to was a 2-1 decision. The 2 in the majority denying the motion to change the venue and move it out of Boston didn't give any reasons at all, but the dissent said that this case, from what he's seen, is a much stronger case than the Oklahoma City bombing case for a change of venue. And the dissent also mentioned that there were, I think, more than 9,500 pages of documents that the Court of Appeals panel had less than 6 hours to digest, and he said that they should take more time, but the 2 in the majority wanted to just move it right ahead. And if there was ever a case for a change of venue, this is the one.